Hello, this is Matt on the Moon Lambo channel. This will definitely hit the Ripple lawsuit. It's really just a question of in what way and to what degree. But in this video, I'm going to show you, in former SEC Chairman Jay Clayton's own words, that what he has stated, it's in direct conflict with the logic behind the SEC versus library case and their LBC token, which stands for Library Credit Token. Now, as it turns out, more people are using library credit, LBC, than trading it on secondary markets. And the outcome of the library case will, to whatever degree, impact the Ripple case, unquestionably. And so it's definitely important to be aware of developments and potential outcomes surrounding that lawsuit. And even though it won't result in, immediately anyway, in binding precedent for the entire asset class, you know that the SEC, assume they get a good ruling on the library case, they're going to be filing documents in the Ripple case. You better frickin' believe it. They absolutely will. And then the degree to which that's going to matter, a lot of moving parts, depends on the outcome of the case. Pay attention. This really matters here. I also want to share with you this story from the Crypto Basic titled Ripple vs. SEC. New facts further suggest William Hinman's links with Ethereum before his 2018 Ethereum free pass speech. And what's covered in this article actually comes directly from what was uncovered by my fellow XRP YouTuber Crypto Eddie. So I wanted to, at the outset of this video, give a shout out and credit to her. I always like to give credit where it's due. And it was kind of unfortunate. Unless I missed it, going through this article, I already knew that she had uncovered this and talked about it the other day. Unless I missed it, I didn't see them giving her credit here, so I wanted to make sure, because I'm going to cover this in the second part of the video. To me, again, always give credit where it's due. But before going any further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, we got to start right here. What's on your screen right now, this actually comes from Princeton University's website. It's titled SEC Chairman on Cryptocurrencies and Initial Coin Offerings. And this is from May 31st, 2018. So almost 4 years ago, back when Jay Clayton was the SEC chairman. And the reason I got to highlight this is because I'm going to share with you what he said and what makes something a utility. What means that there's like a utility. How did he classify it? I think he said utilities are just a security, one versus the other. I'm going to share with you the exact quote, but I want to give you his exact words. But the reason that I'm going to share with you this part first is because immediately after this, I'm going to share with you thoughts from an attorney within the XRP community who points out exactly what makes in the case especially of the library token, what makes it a security or not a security, and like what's actually being argued. And it's just so interesting because if the SEC was going by what Jay Clayton was talking about here, they wouldn't be suing Library in the first place. So check this out. U.S. Securities and Exchange Commission Chairman Jay Clayton spoke at Princeton University on April 5th at the invitation of the JRC PPF undergraduate associates. Clayton, the country's top securities market regulator, discussed the SEC's evolving views on whether digital coins should be classified as securities and the need for government oversight in the context of rapid technological innovation. Now, according to the regulator, many initial coin offerings that have labeled their products as utility tokens may actually be securities. Clayton referred to laundromat tokens to explain the difference between a utility token and a security token, noting that the SEC will regulate the latter, but not the former. So here he says, a utility token will not be regulated by the SEC, but a security token will. And it's just so fascinating because you'll see I'm about to read the quote, it's on your screen. But he, in this quote, recognizes that an asset can go from being a security to a non-security to a security again. He gets that concept. Although technically, I'd parse things out a little bit further. It's definitely not actually the underlying asset. It's more like the way in which it's being sold. Is there utility? Is there a common enterprise? That type of idea. So a little bit different. But regardless, here's what he had to say. This is a direct quote from Jay Clayton. If I have a laundry token for washing my clothes, that's not a security. But if I have a set of 10 laundry tokens and the laundromats are to be developed and those are offered to me as something I can use for the future, and I'm buying them because I can sell them to next year's incoming class, that's a security. What we find in the regulatory world is that the use of a laundry token evolves over time. The use can evolve toward or away from a security. End quote. Well, hallelujah! Wouldn't it be useful to apply that type of thinking to the cryptocurrency asset class rather than suing everyone into oblivion and attacking XRP holders? Wouldn't that be useful? Because this is true. So this concept, it existed before cryptocurrencies existed. But the reason that we're saying we don't have clarity is because the specifics of how this would apply to the cryptocurrencies haven't been explained by the SEC. So if you look at the prongs of the Howey test, what makes something a cryptocurrency part of a common enterprise? What makes it decentralized enough that it's no longer part of a common enterprise? These questions, they don't answer that. But here, damn it, it's on your screen. He said it in a speech. He recognizes that they can change over time. Just refuse to apply that. So think about this. What he's saying here in that quote is that if you have a token, it's actually used for functionality at a laundromat, meaning, washer and dryer. If you're actually using a token for that purpose, of course that's not a security. So he's saying if there's utility, that's what's of paramount importance. So why the hell then are they going after library? And to what degree is this going to impact the Ripple case? That's the question. So check out what Bill, who was on Twitter at Belisarius2020, had to say about this. Attorney within the XRP community. He wrote the following. And this is some excellent insight and perspective. He wrote, I have further considered the library summary judgment motion, and I observe that in relation to the Howey test, the point of attack is that buyers used it not as an investment. And what the lawyers do is to attempt to distinguish the earlier cases on digital assets that had ICOs. Distinguishing an earlier decision, even a binding precedent, means arguing that the facts of your case are so different than the earlier case that the earlier case should not be followed, and the court should, in effect, make a new precedent. So just pause to think about this. New precedent, and in this case, it actually does seem to make sense that there should be a new precedent set because this case is so different than the cases with the ICO with library. No ICO, okay? But the thing is, if new precedent is set, what does that mean? Because this case, understand, it's going to be settled before the SEC versus Ripple case. So to what degree is that going to have an impact? Even if it's non-binding, to what degree is it's going to have an impact? For sure, one way or another. Anyway, Bill continues. This extract from the library submission shows that this is what libraries' attorneys seek to do. And the several points they raise are the fact library had no white paper, had no ICO, and that sales were to users on an already functioning, usable network who used it on the network. Folks, doesn't that sound kind of like what I was reading from Jay Clayton a minute ago, which he was citing would not be a security? Laundromat tokens. Doesn't it sound more like that? If there's a cryptocurrency that's created and then it's sold, but it's used for a purpose, doesn't that kind of sound like there's no chance in hell it could be a security? Well, that's kind of curious. Then why are they going after the library? Well, because they want to be rulers of the world, basically. They want to be rulers over everything that exists because they are complete asshats. Working at an asshattery. That's what the SEC is. Bill continues. Library asserts that in each of the ICO cases, there was no already existing functioning ecosystem that had been launched, and the tokens in those cases had no utility when sold. A key fact library relies on is that buyers of LBC used it on the library network rather than to speculate on secondary markets. As I explained in a previous tweet, library has adduced evidence from 295 people to show this use on the network. This evidence supported by expert evidence that there were more people using LBC on the library network than trading it on the off-chain secondary market. I find this to be a compelling fact. Yeah, let me pause right there. I find that compelling too. Provably the case that more people were using it than speculating with it. What are these asshats doing? You've got former SEC Chair Jay Clayton talking about this Unbelievable, folks. Absolutely unbelievable. Like, unquestionably the case. This is why it grinds my gears. The bill continues, though. It says, library stresses the consumptive use of the LBC token, which is a factor referred to in both the Hinman speech, excuse me, in the SEC's 2019 framework document, as indicative of the Howey test not applying to LBC. Let me pause to say again, yes, correct, because even if you listen to former SEC chair asshat Jay Clayton's own words, this doesn't apply. They shouldn't be suing library, folks. And they have to know this. They investigated. They have to know this. Bill continues. Overall, this is a cogent argument, relying on both expert and ordinary evidence to show that the Howey test does not apply to LBC and that the library case is no different to earlier ICOs. Is very different to earlier ICOs, from which decisions this matter should be distinguished. Absolutely and incredible. So, what actually is going to happen here? Some sort of precedent's going to be set. And you know, if it's in favor of the SEC, they're going to file something. And I don't know what to expect at this point. I'm hoping that justice is done and library ends up being vindicated and the token's allowed to continue to exist. It's functionally useful and required in order for the network to exist, for the use cases that they've been applying it for. Otherwise, you're just going to throw it all away. You have to throw away everything. If it's not decentralized, also, it does not work for reasons I've talked about in previous videos. They're just attacking, folks. They're just attacking. Now, on to this next piece, and again, this is titled Ripple versus SEC. New facts further suggest William Hinman's links with Ethereum before his 2018 Ethereum Free Pass speech. It comes from the Crypto Basic. Many Ripple investors still regard William Hinman, the former director of SEC's Division of Corporation Finance, as the major cause of XRP's underperformance following his 2018 comments stating that Ethereum was not a security. Hinman's speech paved the way for Ethereum to become the second largest cryptocurrency by market capitalization, of which XRP was a major contender at the time. Ripple, they mean XRP, enthusiasts believe that Hinman made the Ethereum Free Pass speech because of his affiliation with Simpson Thacher and Bartlett LLP, a member of Enterprise Ethereum Alliance, or EEA for short. And Simpson Thacher, of course, was Bill Hinman's law firm. That's the law firm he worked at before working at the SEC, and then he went to work for them again after leaving the SEC and doing stuff that benefited Simpson Thacher, just getting paid $15 million, and it's completely ridiculous. Anyway, piece continues. It is worth noting that the EEA is responsible for marketing the Ethereum blockchain as an enterprise solution, and as such, Hinman was accused of possible conflicts of interest during his time at the SEC. Now, this is where it gets particularly interesting. What many investors did not realize, they said, Ripple again, it really grinds my gears. How do you not know this in 2022? I'll just fix it. What many XRP investors did not realize is that the fact that Hinman's affiliation with Ethereum goes beyond being a managing partner at Simpson Thacher. The SEC's former corporation finance director was the managing partner of Shearman and Sterling's San Francisco and Menlo Park offices prior to joining Simpson Thacher in 2000. How about that? A different firm way back in the day. According to an EEA report, Shearman and Sterling officially became a member of the Enterprise Ethereum Alliance and Legal Industry Working Group on August 14, 2017, less than 3 months after Hinman was appointed director of the Division of Corporation Finance. In the first month of Hinman's stint at the SEC, he proceeded to appoint Robert Evans III as the deputy director in the agency Division of Corporation Finance. Evans was also a managing partner at Shearman and Sterling LLP before his appointment. While it is not clear whether Hinman and Evans collaborated to favor Ethereum over Ripple, of course they mean XRP, there is a possibility of conflicts of interest, which resulted in ETH becoming the undisputed second largest cryptocurrency by market cap. So you just pause to sit here and think, all of this, everything that we've been reporting as a community for over the year, everything that we've discovered, everything we've been talking about, now there's this next piece right here. It's just another thing. It's just one more thing. How the hell could Hinman not have known? Unbelievable. And then the piece states, meanwhile, less than a month before Hinman made the speech declaring ETH as non-security, Shearman and Sterling LLP wrote about the regulatory scrutiny facing Ethereum and Ripple. That's, I'm so amazed and flabbergasted by the fact that either this is the biggest string of coincidences in the history of mankind, or something nefarious is going on here. Which do you think it is? Tell me if you're flabbergasted about this, or if it perhaps steams your vegetables. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.